Hey everybody. Today we are going to talk about the juvenile court process. To do that, we're going to talk about some of the terminology that's used in juvenile court. We're going to talk about jurisdiction, transferring, we've talked a little bit about already. We're going to talk about that a little bit more in depth, and then some of the steps in the court process and the options that we have. So first and foremost, when we're talking about vocabulary, remember labeling theory. Now that's going way back to an earlier module, and that labeling theory is the idea that we have primary and secondary labeling. Primary is that initial offense. If they're given a negative label, they have a negative experience, they're much more likely to commit additional delinquent acts. And so we really try to watch what labels we give youth. And because of that, we have a different vocabulary. I like to call it a kinder, gentler system in the vocabulary that we use. For example, in the adult system, we have a crime. In the juvenile system, we have a delinquent act. Adults are arrested. Juveniles are taken into custody. Adjudication is the concept of finding a juvenile guilty. If they are adjudicated delinquent, that's basically they're found guilty. The adjudicatory hearing is the same as the trial. Disposition is the sentence. Kids don't go to jail. They might be sent to a detention facility or a shelter. Shelter is a non-secure jail. And then aftercare is the same as parole in the adult world. And again, ultimately, we do this to be less intimidating, and really it's an entirely different philosophy. And once again, I'm going to talk about balance. We're really trying to weigh the best interests of the child and community protection. Both are important, and so we're going to weigh them. And that's really going to determine, is there a treatment plan that's available, or does this kid need just punishment? And that's going to depend on the crime. And as I said, remember, this is based on the civil system. So referrals to the juvenile court system, police, family, schools, social services are primarily where kids are being referred from. And with that, remember, that is also that one-pot approach. Remember those 4 different categories that the juvenile justice system deals with. So that is all covered under the jurisdiction of the juvenile justice system. Of course, we have the geographic jurisdiction. We have lines. A lot of times these are drawn by county, and that's where the court system is going to cover it. So that's jurisdiction. Venue is the location of the trial. Now here gets a little bit interesting. So if you are an adult and you've committed a crime, you will have court where that crime was committed. So let's say your entire family is vacationing in Hawaii. You get arrested for drunk driving in Hawaii. Technically, unless you can hire a really good lawyer and get some motions in there, your court case is going to be in Hawaii. Now let's say your 16-year-old child was with you and they get arrested or taken into custody, of course, what we call in juvenile world. Their venue is going to be where that child lives. There isn't the expectation to go to where the crime happened. And so venue is different between juveniles and adults. Ultimately, 2 things that really become important in determining jurisdiction are their age. This varies by state. Again, it's going to be really important for you to understand what age your juvenile justice system begins at as far as being adjudicated delinquent. In Minnesota, the youngest we will bring in a juvenile for delinquency is age 10. But again, that varies by state. Then we're also going to look at conduct. What is the child being accused of, and how serious is it? Based on those factors, again, they might make the decision to transfer or waive some kids. There's some public pressure about that. This whole crime control, get tough on crime. The public is wanting juveniles to be waived to the adult system. But it's important to keep in mind that statistically, we waive very, very few kids to the adult system. But if we are going to waive a juvenile to the adult system, we basically have three different options. The first is judicial waiver, or what's often called discretionary, up to the judge. The judge is going to take into considerations the juvenile's age, the seriousness or how sophisticated their crime was, their criminal history, and amenability to treatment, meaning is there a treatment option available for them in the juvenile justice system. The second is called presumptive, or often referred to as concurrent jurisdiction. Here there's going to be a minimum age. So in Minnesota, for example, that minimum age is 14. Here the prosecutor is basically going to have the discretion to make the decision, but ultimately the judge needs to agree with it. Then lastly is statutory, or what we call mandatory exclusions. This is decided by our legislative system, where ultimately the judge and prosecuting attorney has no discretion. It's written right into statute. So for example, in Minnesota, it is written right into statute that if a child is being accused of first-degree murder and is the ages of, 16 or 17, they must be waived to the adult court. There's no ifs, ands, or buts about it. They will be. So that's a mandatory or statutory exclusion. The Sixth Amendment requires that we demonstrate anyone who is brought to trial must be competent. Now, this is interesting because in the adult world, we assume that someone is competent. We have to prove that they're not. If the defense attorney wants to take that right, we have to prove that they are not competent and are not able to understand the process. So it's different than pleading mentally ill. We have to demonstrate that they are competent enough to understand the process. In the adult system, it is assumed that they're competent. In the juvenile system, it is assumed that they are not competent, and we have to demonstrate that they are. And as I said earlier, age 15 and younger, immaturity is seen as similar to being developmentally disabled. What's interesting is juveniles, as well as adults in general, that are involved in either the juvenile or adult criminal justice system have significantly lower IQs overall than their counterparts in the general system. And so that's something that the court takes into consideration as well. All right, so we talked already about law enforcement, and again, law enforcement has huge amounts of discretion in determining what's going to happen with a child. Let's say that police officer decides that they're going to write a report and forward it to the county attorney. The first step that is going to happen is intake. And basically this is where probation is going to step in, and they're going to see if there is a program that might be appropriate for this juvenile that diverts them away from the system. Because again, the bottom line is we want to keep as many kids as we can away from the juvenile justice system if possible. So diversion programs in this intake process are heavily relied upon. If it's determined that there is not a diversion program that's appropriate, then the second question we need to figure out is about detention. Detention is defined as temporary being the key word here, and safe custody. As I said, the judge's preference is if they can send them home to the parents, they will. If they are not able to send them home with the parents, then they need to figure out, can this child get by with non-secure, or do they need secure? Whether or not they are placed in non-secure or secure doesn't matter. They need to have a detention hearing within 72 hours to see if continued placement is still appropriate, or can we now send that child home. In the adjudication process, so again, this is the trial process in the juvenile justice system. The first thing that's going to be filed is a petition. That's going to outline what the juvenile is being charged with, how we've established jurisdiction, and if there's any options available at that time. We'll then move to the adjudicatory hearing. And again, this is always decided by the judge. It's always a bench trial. Remember, McKeever versus Pennsylvania said juveniles do not have the right to a jury trial. So this decision is always going to be made by the judge. If the judge adjudicates the juvenile as a delinquent, it's basically similar to an adult or a guilty plea, we move to the disposition. Disposition is the term that we use for sentencing in the juvenile world. Now, ultimately, in the juvenile justice system, the judge has tremendous discretion. In the adult world, of course, we have sentencing guidelines. We have things, set and outlined. For this crime, this is the punishment. For this crime, this is the punishment. It's not that clear-cut in the juvenile justice system. The judge has tremendous discretion, and ultimately the judge's decision is really going to be based on what rehabilitation options are available. We really believe children are worth saving, and so what can we do to help this child? What's in the best interest of this child to help them become a productive citizen in our society? The least likely option is institutionalization. Judges don't want to send kids to detention. We know statistically, once a child spends time in detention, especially secure detention, the chances of becoming a productive member of society are greatly reduced. But remember also, we need to balance. That first slide we talked about balancing the best interest of the child and public safety. Public safety is still really important, and we really need to balance those two. One of the challenges in this is that when judges make decisions based on the best interest of the child and focused on rehabilitation, there's not a whole lot of public support. Again, the public really wants us to see us locking up these juveniles. They think that that punishment is going to deter crime, even though we can throw a million studies at them that says that detention or punishment isn't necessarily the best option. We don't have a lot of public support. We also have very, very limited resources. These programs that we want to send juveniles to that are focused on rehabilitation are very, very expensive, and they always suffer from understaffing because they don't pay very well. And we have very limited programs. For instance, where I live, so I am near St. Cloud, there is an absolutely fantastic program in Minnesota, but it is 5 hours away from St. Cloud. That's challenging. In St. Cloud, sometimes the closest secure bed is in Wilmer, which is about an hour away. And so, we're very challenged and limited in sometimes our resources. The bottom line, the Supreme Court says you will use the least restrictive option available. And so we always need to be complying with that. Some other options that we have, the first is teen court. Now, I would really encourage you to Google. I'll be posting some videos as well about teen court. Basically, this is an option in some jurisdictions where the school system, so all of the court personnel are youth. They're youth who are generally really, really good students, not in trouble themselves, are interested in working in the court system sometimes in the future, and they go through this training and they develop their own court system. So I like to call it really, it's a specialized court that is positive peer pressure. Now ultimately the juvenile that's going to go to teen court is generally between the ages of 14 and 16, and they're a first-time nonviolent offender. We are not bringing violent offenders to youth court. The juvenile has to acknowledge their responsibility. In the adult world, we would call that plead guilty, but ultimately the juvenile needs to acknowledge their responsibility in what they're being accused of. And then ultimately, this teen court or youth court decides what their punishment or what their sanction is going to be. A lot of times it's built around restorative justice principles. For juveniles that enter the system based on substance issues, they have drug court options for youth. Now, you might be familiar with drug courts for adults. Similar concept, only based around youth. It is an intensive treatment program, rehabilitation program, to help them become sober. And ultimately, in order to qualify for it, obviously they need to demonstrate substance abuse issues, and also must only have nonviolent offenses. If they got violent, they are not appropriate for drug court. All right, BARGE. We've talked about this in a previous week. BARGE is balanced and restorative justice. So basically, we know that traditional restorative justice really focuses on the victim and the community and the offender. Balanced and restorative justice takes that one step further and says we also need to incorporate public safety, accountability, and competency development. So how can our plan for this juvenile incorporate all 6 of those edges of those double or 2 triangles? Really focus on the best interests of the child, rehabilitation, but recognizing the role that the community and the victim play. So a couple options that we have in restorative justice for youth. The first is community reparative boards. Now, basically, this is very similar to a board meeting. However, these board members receive special training, and they have face-to-face meetings where they discuss what happened, they discuss the offense, and help the juvenile understand the negative consequences, how they hurt people based on their actions. And then what I really like about this is that they develop some type of sanction with the juvenile. So ask the juvenile, what do you think is going to help you? And this board together creates a plan and then implements that plan with the appropriate people in place, and then they continue to monitor and follow up with that juvenile. Another option is family group conferencing. Here we basically bring in the victim and their support system, the offender and their support system, and a facilitator. Now I've been involved with family group conferencing, and it's very, very interesting and very effective. And basically together, so the victim and their support system and the offender and their support system, through the facilitator, discuss how they were harmed, what happened, and how we can fix it. And so it can be very, very effective in bringing those folks together. No matter what we're doing, our best practices are always to give the victim a voice. That's really what restorative justice is about. Yes, we still hold people accountable for the choices that they make, but we really need to make sure the victim knows that their opinion matters, and you know, we have choices along the way. Restorative justice is not without criticism. Some argue that it net widens. This is a concept that says rather than narrowing the pool of juveniles that we bring into the system, it actually widens the net because restorative justice, we're doing more with kids that we may not have considered or done anything with. Restorative justice programs can also be very, very expensive, where sometimes we're spending money on kids who are, you know, the least violent or least bad in their crime. And we ultimately need to remember that by simply doing nothing, basically 70% of kids who have been caught committing a delinquent act, just that contact with the police or maybe just initial contact with the justice system will never do anything wrong again. And so we really need to take into consideration that the label we're giving these kids. EJJ, Extended Juvenile Jurisdiction Juvenile, is an option in Minnesota, where I'm from, and I know many of you are as well, but we also are seeing this in other states as well. It's a blended sentence. And this is often the last chance for juveniles who have had extensive contact with the juvenile justice system. So in this blended sentence, so they stay in the juvenile system. They don't get transferred or waived to the adult system. However, they are given a juvenile disposition saying, here's what you have to do. Here are the conditions of your sentence. And then they're also given an adult sentence that hangs over their head. We call it a suspended adult sentence. And basically, this blended sentence says, here's your last chance. This is what you need to do to fulfill your juvenile sentence. If you don't, this is what's going to happen as an adult sentence. Excuse me. And so we're seeing some jurisdictions having this as an option. All right, assignments this week. We're winding down to the end of the quarter. Please read Chapter 6 and the corresponding links. The discussion forum is talking about when juveniles should be certified or waived to the adult system. So your post should talk about when you think that should happen and what age is appropriate. Your final project is due. Now, we've been working on this all quarter. Remember the goals of the assignment. You need to look at the history, the current context, 2 benefits, 2 drawbacks, and your opinion. Make sure you incorporate the feedback I've been giving you on those different project pieces that we've been talking about. Read the announcements. Check your email. I did a live lecture on the project. Make sure you are utilizing all of those resources to fine-tune this project. All right, that is all I have for you. If you have any questions, again, please always give me a call.